Clerk has asked me to just clarify one thing again. The document that the clerk just tabled is in English only. Would we have permission to circulate it again? Et on va faire la traduction après?
And we'll do the translation afterwards, or would you prefer not to have it until it's translated? Chair.
He provided that he received from the Justice Department on solicitor-client. Sorry.
How much time will it take to translate it? Well, it's roughly 2.5 pages. Clerk, how much time should it take? It's the same thing as I said earlier. I'm somewhat surprised. We should have this in both official languages. I don't want to object. I've been here on the Hill for 25 years, and I've understood for quite some time that, and the two official languages are English and their translation. But it depends who the witness is, but I agree entirely that we have to translate it. Mr. Berthold? Chair, since this cause does come from the clerk of the Privy Council, I would assume that this person would be very aware of the obligations in terms of what happens here in the committee. And in this case, we will wait for the translation of this document. It's perfect. If you're not in a rush, we'll wait for the translation and we'll wait for it to be translated probably next week around Tuesday or Thursday. All right? Perfect.
Chair, I look to you for guidance as to the receivability of the following motion, but I'll read it and then explain why I believe it's critical. My motion is that the committee A, call on the Prime Minister to amend the Order in Council number 2019-0105 to allow the former Attorney General to speak openly about any matter salient to the SNC-Lavalin matter after January 14th, and to call as witnesses as soon as possible the following 4 individuals: Jessica Prince, former Chief of Staff to Ms. Wilson-Raybould; Katie Telford, Chief of Staff to the Prime Minister; Elder Marquez, Senior Advisor to the Prime Minister; and Mathieu Bouchard, Senior Advisor to the Prime Minister. Mr. Chair, the reason I think this is so important, if I may, is that there were 2 meetings that we heard a lot about today. One, November the 22nd, where Madam Wilson-Raybould met with Mr. Bouchard and Mr. Elder. And then there was a second meeting that her Chief of Staff took with Katie Telford. I think it's really important from a matter of natural justice and fairness to those individuals that we hear from them. Let me explain why. It's hearsay what Ms. Prince recorded about her conversation. And with respect, she said some very disturbing things attributed to Ms. Telford, namely that we don't want to debate legalities anymore, direct quote. Now, in fairness to Ms. Telford, we need to have her here, and we need to have also Ms. Prince here so we can get at the bottom of that, what appears to be a very serious issue. I think it's fair to both of them to do it. I think it's grossly unfair to not have that testimony. And lastly, when it comes to the November 22nd meeting with Mr. Bouchard, Mr. Marcus, and the former Attorney General, there was some very serious things said about enough is enough, I keep saying no, I've made up my mind, etc., and yet we know what transpired thereafter. My point is, fairness requires that we hear these witnesses. And as to the first part of the motion, it seems grossly unfair, with all due respect, that we were allowing Mr. Butts to come and talk about what happened after she was removed from cabinet, but she can't do so. So my plea to this committee is in the interest of fairness that we allow this to occur.
Thank you very much. The motion is receivable. There's no problem. Yeah, we'll get a speakers list. I would just note, I don't believe he spoke about the period after she became the Veterans Affairs Minister. He was speaking about the period.
He talked about when she was removed from cabinet today.
We'll have to all look at the transcript. I think he was largely talking about the period in between the 2 ministers during the shuffle period, which was before the new appointment. But we'll all have to look at that. So in any case, the motion is receivable. And can I just get a speakers list? Who wants to intervene? I have Mr. Polyev, Mr. Fraser. Ms. Raitt, Mr. Cooper. Okay, Monsieur Berthold après. Sorry, Mr. Polyev?
Yes, Mr. Chair, it's necessary for Madame Jody Wilson-Raybould to return. We now have contradictions in between witnesses. Another good reason why we should have allowed them to swear an oath before they spoke. I still don't understand the government's objection to having people swear an oath and assert that they will be truthful. But what contradiction worries me the most is that.
Are you moving an amendment right now to Mr. Rankin's motion?
No, I'm speaking to the motion. You said.
But the motion doesn't involve Ms. Wilson-Raybould.
Sorry, I misunderstood then. I thought the motion did involve Mr.
No,
Raybould.
no.
Okay, I apologize.
I moved that motion this morning, and I was defeated by the Liberal majority,
I see.
Mr. Poilievre. I'm
Okay.
now asking for 4 witnesses, separate from that particular witness, to
Yes.
come forward.
Okay, I move the amendment that Ms. Jody Wilson-Raybould be recalled, and that the committee call on the government to release any further, release her to tell any further information that happened after she was named Veterans Affairs Minister. Thank you. That's my amendment.
I understand that. So the subsection A of the motion already deals with that issue. You're proposing to add an E and say Jody Wilson-Raybould, former Attorney General, Minister of Justice. It was the meeting this morning separate from the meeting this afternoon? Absolutely. Okay, so that's the amendment. Mr. Poilievre's amendment is on the floor. Okay. Ms. Raitt?
Speaking to the amendment,
Sure.
Ms. Wilson-Raybould has sent a statement to the media this afternoon indicating she would be willing to reappear at the committee. I think as a result, she is clearly doing what Mr. Butts did last week, which was asking for an opportunity. So that's why we moved the amendment to make sure that we were able to consider this with the new evidence that has recently arisen.
Mr. Fraser? Well, you had the floor and then it went to Ms. Raitt. I'll come back to you.
Thank you.
Okay, so Mr. Fraser has given you his. We'll come back to Mr. Fraser. Who's next? Mr. Poilievre?
Thank you, Mr. Fraser. I appreciate that. Ms. Wilson-Raybould testified that both the clerk and the Prime Minister on multiple occasions and on separate dates told her that if she did not immediately proceed towards a deferred prosecution agreement to shelve the charges against SNC-Lavalin, that the company would move its headquarters out of Montreal. We know that's impossible because of a loan agreement between the company and the Caisse de Dépôt that is part of a $1.5 billion financing deal. So somebody would have been telling her a blatant falsehood in an attempt to get her to sign the deferred prosecution agreement with false information. Now, today, Mr. Wernick denied having said that. Ms. Wilson-Raybould's testimony alleges that he did say it on 2 separate occasions, once in September and then once again in December. So we have a major divergence of factual accounts between these 2 witnesses. Mr. Wernick has been given a second chance to come back and testify, whereas Ms. Wilson-Raybould has not. She would have a stronger case for returning because, as we all know, she was prohibited from telling her entire story when she first came before the committee. So the government must release her, eliminate completely the gag order that prevents her from telling the whole truth so that she can come back. And I will close by returning to my first point. It has been alleged, and I argue been proven, that members of the Prime Minister's inner circle pressured Madam Wilson-Raybould into making a decision she did not want to make. However, it may be more serious than that. If the Prime Minister, the Clerk of the Privy Council, and other senior staff deliberately told a falsehood to Canada's top law officer to trick her into shelving criminal charges, then that could rise to a higher level of criminal conduct. And we have significant evidence that such a claim was made by those officials, including the Prime Minister, to Madam Wilson-Raybould. It is incumbent upon us to have her come back here, now that Mr. Wernick has had an opportunity to contradict her, and tell her side of the story. Thank you.
Thank you. I'll just note again, for the purposes of the record, the amendment is going to be deemed to be made by Ms. Raitt because she put up her hand after, and Mr. Poilievre is not a member of the committee, so he can't put an amendment. So the amendment is, yeah. So, Mr. Fraser?
Thanks very much, Mr. Chair. A few things here. I mean, the way that the committee has functioned on these meetings up to this point is in a step-by-step fashion in order to determine the next steps, in order to determine what we've learned at the various meetings regarding the testimony, and then to have a subsequent meeting involving next steps. I know that was the motion that convened to the parameters of today's meeting, was in order for us to hear the testimonies today, have an opportunity to reflect on it, and then at the following meeting determine the way forward for the committee, including whatever next steps may follow. And in previous times we've done that, we've seen further witnesses come forward. I note a couple of things. I note, first of all, that Ms. Jody Wilson-Raybould had the order in council, which allowed her to speak to a number of things that were not able to be spoken about by Ms. Drouin and Mr. Wernick the last time that they were here. And so that was one of the main reasons to have them back. I recognize as well Ms. Jody Wilson-Raybould had the opportunity to have an extensive opening statement, and that was obviously given to Mr. Butts today as well. But also, I think she testified for a period of about 4 hours. So it's obvious we have a lot of information before us now as a committee. My suggestion is that we reflect on today's testimony and do what the motion convening today's meeting had anticipated, which is at the next meeting, determine the next steps. So I think for all of those reasons, it's important for us to see that next meeting be when we come back on March 18th and determine where we go from there. So for those reasons, I'm asking to put consideration of the motion over to that date.
How would okay. So unless that proposal is acceptable, what we would need to do is deal with the current amendment with Ms. Raitt and then move back to another amendment from Mr. Fraser to defer it to March the 18th. Is that March 19th? March the 19th, Tuesday, March the 19th at 8:40. Mr. Rankin?
I'd like to respond to
Sure, of course.
my friend Mr. Fraser, but I just want to make sure I understand what we're voting on. Are we voting first on the amendment, namely that Ms. Wilson-Raybould be invited to return? Or are we talking
unfortunately,
about the main motion?
What I'm told is because that would, you can't sort of, because that was not, unless you would say, just one question. Would you have considered that to be a friendly amendment
Yes,
to the
of
original
course.
motion?
Indeed.
So then can we consider, okay, Mr. Clerk, as opposed to making it an amendment, Mr. Rankin considers it a friendly amendment to the original motion. So can we just consider it incorporated into the original motion? Yeah. So we're adding one other witness into the original motion. Now Mr. Fraser is suggesting to defer that until Tuesday the 19th.
And that is what I wanted to respond to.
So that works perfectly because then we can deal with it that way. And then, well, no, I'm not sure everybody's in agreement, but I think that at least we know what's on the floor now. So there was a motion. Ms. Wilson-Raybould is now incorporated as one of the people on the list of the motion, and Mr. Fraser is asking for it to be deferred until the 19th. And so that's the amendment on the floor right now, is Mr. Fraser's amendment. Okay. And now I'm going to come back to the speakers list. Mr. Cooper, Mr. Berthold, and Mr. Rankin are next on the speakers list.
Yes. Okay.
Yeah.
Well, thank you, Mr. Chair. And Mr. Fraser suggests that we reflect on this behind closed doors instead of before the public. That has been the consistent way that Liberal MPs have approached these issues. At every step of the way, they have tried to block and obstruct hearing from witnesses until they really feel that they have no choice. It may be, and it may very well be, that we need to hear from additional witnesses, but in the face of the testimony of today, it is inconceivable to think that we would not hear from Jessica Prince, Katie Telford, Elder Marquez, and Matthew Bouchard. Mr. Butts, very conveniently, we heard from Mr. Butts, who spoke to his version of events on the November 18th December 18th meeting. And so it seems perfectly appropriate, in fact necessary, to hear from the two other witnesses, two other participants at that meeting, Ms. Prince and Ms. Telford. It's completely clear that Elder Marquez and Matthew Bouchard repeatedly met with or communicated with Jody Wilson-Raybell's Chief of Staff and Jody Wilson-Raybould herself, including on November 22nd, but at other dates with her Chief of Staff, including October 18th and October 26th, to pressure or to reiterate the need for, among other things, an outside opinion. So how can we not hear from those individuals in order to understand exactly what was discussed and in order to understand the full context? And as for Ms. Wilson-Raybould, it is absolutely clear that we need to hear from her about the period after she was fired as the former Attorney General. And as Mr. Poilievre said, it is all the more important in light of her testimony that on two occasions the Prime Minister and the Clerk of the Privy Council raised an impossibility with her, and that is that SNC-Lavalin would be moving its headquarters. And Mr. Wernick, after being questioned by Mr. Poilievre for about 5 minutes, dodged his straightforward question about whether or not he had ever said that, and then he flat out denied that he ever said it, contradicting himself when he appeared before our committee last, where he stated, quote, that we openly discussed about the company moving or closing. That was his characterization of what took place at the meeting with Jody Wilson-Raybould when she said that she was threatened not once, not twice, but 3 times by Mr. Wernick. He said 2 weeks ago that he talked about moving the company, and then after he was cornered, he suddenly issued a blanket denial. We need to hear from Jody Wilson-Raybould as well. So, why delay, and why should we have to wait 13 days to make a decision? What we need is this process to continue in an expeditious fashion. There is no basis for why this should have to wait, this decision should have to wait another almost 2 weeks when it is so painfully obvious that all of these individuals, these 4 individuals, plus Jody Wilson-Raybould, are necessary to hear from in order to understand the full truth.
Monsieur Berthold?
Mr. Berthold, thank you very much, Chair. It was a real pleasure and honor to be with you today on this committee. I learned a lot, and unfortunately, there's still a lot to be said because we heard from Mr. Butts, and the Justice Committee accepted to hear the testimony of Mr. Butts right in the middle of a break week, and now there's going to be an amendment just to make a decision. So we're going to decide when we're going to hear a committee, and I find this a witness, and I find this unacceptable. Ms. Wilson-Raybould said on several occasions that she experienced veiled threats and undue pressure. And I heard testimony that this wasn't threats, that they were just requests that were made to ask for outside legal advice. So there's two totally different opinions here. And it's very rare in such a case when there's a conflict. When we ask the person who would have made the veiled threat to criticize themselves and say, oh, well, I didn't make a threat. When a person says that they were subject to undue pressure, it's usually that person you have to ask and believe their perception of the situation, and not the person who harassed them and asked them how they're managing a file, whether it was appropriate or not. I think we have to believe the person who received the inappropriate pressure. Chair, we were able to hear today Mr. Butts say that Ms. Wilson's-Raybould demotion had nothing to do with the SNC-Lavalin affair. And this is not what we can infer based on everything that's happened. And we'd like to hear what Ms. Raybould has to say about this situation, because she wasn't authorized to talk about it. And this is totally unacceptable. We can't allow Mr. Butts tell us today that the demotion of the minister, the AG, had nothing to do with the SNC-Lavalin affair. And we have to allow Ms. Raybould to come and say whether she felt that this was directly related to this affair. Chair, in conclusion, in Ms. Wilson-Raybould's testimony, she often talked about veiled threats. And what is the biggest threat right now facing the cabinet? Well, that's facing losing her job, and that's to be demoted, to lose her position. Chair, if you looked at just the facts, Ms. Wilson-Raybould did lose her position. These veiled threats were real threats, Chair. And it's important to hear what Ms. Wilson-Raybould has to say, and we have to hear her as quickly as possible, and not just rely on the Liberals' political agenda. We owe it to Canadians to shed light on this as quickly as possible, and we owe it to Canadians to hear all the witnesses and the truth as quickly as possible. Thank you very much, Mr. Rankin.
Time to wrap it up soon, I appreciate, but I just want to say to my friend Mr. Fraser in response to his comments that yes, indeed, it has been our process to deal in camera with the selection of witnesses. That's the context, however, where we're trying to not embarrass people in public about which witness we choose, which expert we like over another. I think that's the purpose for which we've done that. I don't think it's written in stone. Now, the Liberals' motion was that we proceed step by step, all right, but I think we can agree that circumstances are a little different today. We have some serious testimony that seems to be contradicted, and I just think it's a matter of fairness to Ms. Katie Telford to defend herself, to be given an opportunity to confront the statement that I read into the record, that our witness, Ms. Wilson-Raybould, read into the record. And I think that if it's a question of her extensive statement to which Mr. Fraser alluded that she did last time, and I'm happy to have her waive such a statement. We don't need it now. We're getting into the facts and so forth. So I think that the Liberals on the committee, if they vote down now an effort for us to tell Canadians we're going to continue to get to the truth of this, they're doing a disservice to our committee. They're doing a disservice to the notion of getting to the truth. I agree with Mr. Cooper. It's painfully obvious these witnesses must be heard. Let's just get on with it.
Very much, Mr. Rankin. Anybody on that side wish to respond? So basically, the clerk has written out the correct procedural amendment to give effect to what it is that Mr. Fraser suggested, which is that all the words after that be replaced by the following: the committee should consider next steps and potential additional witnesses on Tuesday, March 19, 2019, is what the clerk says is the correct procedural step. So, yeah. That all the words after that be replaced by the following: the committee should consider next steps and potential additional witnesses on Tuesday, March 19th, 2019, is what the clerk says is the right way to do that amendment. So basic, yes. Of course. Thank you. Sorry, briefly suspended.